Good afternoon, Officer Denniston.
Good afternoon.
I understand that you're currently employed with the local police service, sir.
Yes, I am.
And can you outline to the court exactly how long you've been employed as an officer?
Yes, I am a police constable with the local police service. I have been so for the past 19 years.
All right. And can you outline to the court, sir, exactly what your general duties are with the local police service?
At this time, I am assigned to the traffic and marine unit of our local police service.
All right. And I understand, sir, that you have information pertaining to the subject matter that's currently before the court?
I do.
And sir, did you happen to make any notes with respect to this incident in question?
Yes, I did.
And sir, were those notes made at the time of the incident or shortly thereafter?
Shortly thereafter.
All right. And have your notes remained in your possession, sir, since the time that you made them?
Yes, they have.
And have you made any additions, deletions, or any alterations to your notes since the time you made them?
No, I have not.
Do you have an independent recollection of the events as they transpired?
I do.
And you simply require the use of your notes in order to refresh your memory?
That's correct.
All right. If you can then proceed to outline to the court, Officer Dennison, what exactly took place and on what date?
Yes. On August the 17th, 2005, I was on duty in the traffic unit, and I was working from 0700 to 1700 hours that day.
Yes.
At approximately 9:38, I was dispatched to a motor vehicle accident involving personal injury, and the location of that accident was on the Highway 17 West bypass, 2 kilometers east of Highway 69.
That's in the city of Sudbury, sir?
It is.
All right. Please go on.
I was in a nearby area, and my arrival time was approximately 2 minutes. I arrived approximately at 9:40 a.m. When I arrived at the accident scene, there were a number of vehicles that had parked along the side of the road, and I noticed that there was one vehicle in the north ditch that had turned over and was resting on the hood of the vehicle, on the roof of the vehicle. I approached the turned over vehicle, and I noticed a male person who was wrapped in a blanket. And I asked that male person if he was the driver of the vehicle, and he indicated that he was. When I was having this conversation with him, I did detect a very slight odor of alcoholic beverage on his breath. I believed it to be beer at that time. At that point, there was a paramedic who was on site. He was not on duty, but he was in uniform. He was tending to a passenger who was still in the vehicle at the time. I went to the vehicle and did find a second person who was later identified as Peter Green, and he was a passenger of the vehicle. When we were checking on the passenger, I noticed that there was a number of beer bottles inside of the car. One had been smashed, probably as a result of the accident, and 3 bottles of white rum were inside as well. That raised my suspicion, and I went back to speak with the person who was later identified as John Doe and the driver of the vehicle. I asked him to come into my police cruiser for investigation reasons, and when I got him into the back seat of the vehicle, I realized that I detected a strong odor of alcoholic beverage on his breath, and I also detected that his eyes were bloodshot, and those were some of the grounds that I identified with respect to his impairment. I made a decision that I conferred with my colleagues and made a decision that I would administer the roadside screening test, and I did so. May I refer to my notes to clarify some details?
Yes, sir.
Okay. At 10 a.m., I made a demand for a breath sample, and Mr. Doe did comply with that demand. At 10:04, there was a register of fail in the roadside screening device. The device was number 7410 GLC, and at that time, I placed him under arrest for driving while impaired, read him his rights to counsel, and cautioned him for that purpose.
All right. The individual that identified himself as being John Doe on that particular occasion, can you describe that individual, what he was wearing?
Sure. He was wrapped in a blanket. He was wearing shorts and a green shirt. He had sandals on. That is, he was about 5'8", 165 pounds.
All right. And how were you able to determine that he was in fact John Doe?
He produced a British Columbia license, a valid license from British Columbia.
Would that have a photo identification on it as well?
It did.
All right. And the individual that you identified as...
Identity is not an issue in this case.
All right. Thank you, counsel. As a result of your investigation, sir, what charge did you lay?
I laid under Section 253A of the Criminal Code of Canada.
All right. Thank you, sir.
Welcome.
The breath tech that administered the breathalyzer
The breathalyzer?
or the intoxilizer?
I was.
And what readings did Mr. Doe?
He registered a fail on the roadside screening device.
Now, when he was brought to the station, did you administer the intoxilizer or the breathalyzer at the station?
No, I did not.
And do you know if he provided samples at the station?
It is my understanding that he refused to provide samples of his breath.
So he was charged with refusing to provide a sample.
That's correct.
Now, Constable Dennison, when the Crown was asking you questions, you indicated that you made your notes at the time or shortly after the incident,
That's correct.
and you understand the importance of making detailed notes.
I do.
And the importance of making detailed notes is that you can refresh your memory sometime after the event.
That's correct.
And it's fair to say that you investigate many incidents and accidents on a daily basis as a police officer.
That is correct.
And it's fair to say that your memory of a particular event is much clearer at the time of the investigation rather than 8 or 9 months later.
Some details I recall as clearly 8 or 9 months later. Others, I need my notes to refresh my memory.
So in your particular situation, are you saying that your memory gets better over time?
Not better, but it doesn't fade with respect to some of the facts and issue.
Okay. And when you were in police college, you took a course on note-taking?
I did.
And have you taken any subsequent courses of the importance of taking notes?
I have.
And when's the last time you took a course on note-taking?
It was in the summer of 2000.
Okay. So in the summer of 2000 and in prior courses, you understand or you were taught that you should take detailed notes of important events at the time.
That's correct.
And you were taught that these notes should be detailed with the time and the place of where you're investigating.
Yes.
And you were taught at the time that these notes should incorporate your observations of the events that you feel is important at the time.
That is true.
Now, when the Crown was asking you questions with respect to your observations of Mr. Doe, I noticed that you indicated that when you spoke with him in the police cruiser that he had glossy eyes.
That is true.
But it's fair to say that you didn't make any notation of that observation within your notebook at the time.
That is true.
Because I have your notebook here, or a photocopy of it, and at page 23 of your notebook, you indicate that once John Doe was in the vehicle, I could detect a stronger odor of beer emanating from Mr. Kotar's breath. There's no indication of an observation of red or watery eyes or glossy eyes.
That is true.
So when the Crown was asking you questions, that was part of your independent recollection of the event?
It was.
But wouldn't you agree with me that that would be an important fact to put within your notes at the time?
It was something that I can recall independently.
But as an individual who's taken many courses on note-taking, you would agree with me that an observation of red, watery eyes is an important fact.
It is.
And you neglected to put that important fact in your notes, correct?
That's correct.
And when you arrived at the scene, you had an opportunity to speak to Mr. Doe at the side of the road. He was wrapped in a blanket, I think you said.
That's right.
And at that time, when you first initially spoke to him, you didn't ask him to go into your cruiser at that time.
No, I did not.
You decided to go down the ditch and look at the vehicle that was turned on its roof.
That is right.
And there were other people down there assisting the passenger.
Yes, there were.
And you knew that other police officers would be attending shortly because you were advised by dispatch that other police officers were arriving.
That is true.
And you were advised that the fire and ambulance were also arriving.
That is true.
And they actually arrived shortly after you arrived, within minutes.
They arrived after I made that decision to check on the passenger.
Okay. And when you made that decision to check on the passenger, you made observations within the vehicle at that time.
I did.
And those observations led you to move into a criminal investigation rather than simply a motor vehicle investigation. Would that be a correct statement?
That is correct.
And you would agree with me that a motor vehicle accident investigation is much different than a criminal investigation.
It is.
And you'd agree with me that under the motor vehicle legislation, that a driver of a motor vehicle has to answer questions with respect to a motor vehicle collision. That's legislation that demands that he answer questions when a police officer asks him how the accident happened. Would you agree with me?
I would.
But a criminal investigation is much different because the Charter of Rights and Freedoms protect individuals with respect to police investigations.
That is correct.
Such as the right to silent, the right to remain silent. That's a protection that an individual has?
Yes.
Okay. And when you moved into the criminal investigation, you agreed with me that when you saw the alcohol in the vehicle, you thought that this may be a criminal investigation, that this individual who's a driver might be impaired. You made a decision at that time that you were going to question him more, correct?
I became suspicious at that moment.
Okay.
I only became suspicious at that moment.
And suspicious, that's like a gut feeling?
It's suspicious when you attended a motor vehicle accident and you find alcoholic beverages inside that have been opened and consumed. It is a suspicious circumstance.
Fair enough. So you decide that you're going to approach Mr. Doe again, and you're going to make further inquiries to determine whether or not he's intoxicated or not. Is that fair?
That is fair.
Okay. And when you do approach him, you don't tell him why you're asking him to go in the back of the police cruiser. You don't tell him that you believe that he might be intoxicated and you want him to come back into the cruiser so you can have further investigation. You just say, can you please come with me to the back of my cruiser? Fair statement?
That is true. And
you place him in the back of the police cruiser?
I did.
And this is a marked police cruiser?
It is.
This cruiser would have a division, some kind of plexiglass division between the front and the back of the cruiser?
It does.
If I was sitting in the back of the cruiser, would I be able to exit or leave that spot without your permission? Could I actually open up the door and leave? Or is the cruiser made in such a way that I'm stuck in that cruiser because there's no handles in the back?
You would be exiting when I would open the door for you.
I would need your permission to leave the back of that cruiser.
That is correct.
So I'm detained back there. I'm basically in jail in the back of a cruiser because you've asked me to attend with you and you haven't advised me of your rights. Would that be a correct statement?
No, it would not, because that is the design of the police cruiser. And if you want someone, it is not proper practice to have someone sit in the front of the cruiser with me. There are safety issues that would prevent me from doing that. It is of necessity, if I want to speak to someone, that they're going to be sitting in the back of the cruiser. And that's why he was there.
And before placing Mr. Doe into that cruiser, you never advised him of his rights.
I did not.
And then you continue to ask Mr. Doe further questions.
I did.
And you didn't have a roadside screening device with you at that time?
I did not.
You required another officer to attend?
I did.
And that there was a further delay that Mr. Doe was sitting in the back of a cruiser without his rights being read to him, and he couldn't exit that cruiser unless he pled with you to leave. And if he asked you to leave at that point of time, would you let him out of the cruiser?
I would have.
And you could be described as a person of authority at the time. You were wearing a gun
I was.
that was strapped on your side.
I was wearing the standard police-issued uniform.
And it's fair to say that individuals that are told by a police officer that's wearing a gun in the standard uniform, that can be intimidating for them.
It might be.
And did you ask him if he had a cell phone, whether or not he wanted to contact counsel while he was waiting for the roadside screening device to arrive?
I did not ask that.
Now, when I was reviewing your notes, you indicated that dispatch contacted you at 9:38 a.m. to arrive at or that there was a motor vehicle accident. And in your notes, it indicates that you arrived at 9:37 a.m. When the Crown was asking you questions, you said that you arrived a few minutes after the call from dispatch. So is it fair to say that that notation that you made, there was a mistake there?
There was a mistake made there.
And that was your mistake?
That is correct.
With respect to the vehicle, when the Crown was asking you questions, it's clear that the vehicle was upside down when you arrived at the scene?
It was.
And it's clear that Mr. Doe was not driving the vehicle when you arrived at the scene?
No, he was not.
He was at the side of the road?
He was. He was in a location that was near the vehicle, and that's how when I first arrived, it became apparent to me that he would be involved because of his proximity to the vehicle. And I asked him, were you the driver of this vehicle? And he indicated that he was.
Well, thank you, Constable Dennison. Those are all the questions I have.
Thank you. All right, we're done. That is the situation. There are. Is there anything that you saw off the top that you thought might be difficult for me? Like John was saying, there's another thing with respect to the roadside screen device, and I didn't mention a few things in this particular scenario. When I got him back into the car, I was asking him some questions. I asked him, did you have anything to drink? And the guy originally said I had 2 beer. And I then, not me, of course, the officer who was investigating, pushed that fact and said, how is it, there's no way you only had 2 beer. How many did you have? He changed his story to 4, and then later he changed his story to 6 or 7. Okay? So before he got to the roadside screen device, he came to the point where he was now saying I had 6 or 7 bottles of beer. The other things that weren't released here is this particular accident. What happened was there are markings on the road. The first marking on the road indicating that there was difficulty happened 57 meters before the second incident marking on the road. And the markings are where the individual left the roadway. So he leaves the roadway, gets his vehicle back onto the paved portion, comes back, leaves the roadway again 57 meters further, which may not be that bad, then swerves south onto the paved portion for 59.4 meters, where he turns once again, leaving a skid mark on the road, then heading directly, relatively speaking, directly into the northbound ditch, a distance of another 15.9 meters. So we're looking at an S kind of shape going on here on the roadway that's quite long. So if I was investigating this particular matter, and the point to be made here, even though the law has changed, and I'm going to tell you this most sincerely, in this particular case, you have a guy that admits to drinking 7 bottles of beer. Okay, he admits to driving. He does smell of alcohol beverage, and I'll tell you, the smell of alcohol beverage, in my experience, this idea of a strong alcoholic beverage, it is one of the case law signs, but in reality, it is not that strong. I mean, if the person happens to burp while he's in the back of your car, it might be stronger, but if he doesn't burp or throw up, there's a good chance it may not be that strong, but it's there. And the thing that I'm going to tell you, either it's there or it's not there. So I have this guy in my car. He's admitted 7 bottles of beer. The glossy eyes business, and it was a good point brought up by John Saftik, it should have been in the books. It was not in the notes in this particular case. So what, that is a interesting observation that's written in the Will State. but he has 6 or 7 bottles of beer. He has an odor of alcohol in his breath. And then there's the driving thing. Now, he talks about the fact that a wild animal crossed the road, which is all possible, you know. But I'm still saying if I have a guy that has 6 or 7, tells me he's having 6 or 7 bottles of beer, and I smell booze on him, I'm arresting him. I'm not calling for a roadside screening device. I'm arresting him for impaired driving, and I'm going to take him downtown, and I'm going to have him blow into the breathalyzer machine. Because